Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Wildy, Simmonds and Hill Publishing. They're a first-class publisher, the only law bookshop now in London, but they're very good as publishers as well because they give us book titles which are directly relevant to us in practice, and certainly for people who are litigants in person, I think you will find the books they have very helpful if you have to go to court. The purpose of my reviews always has been, as with Elizabeth as well, that we are here to give you guidance on the books that are available. It's particularly relevant for me in practice because I do need to have some indication of the sort of books I might need to refer to when a particular case comes to court. This book anyway is called Judicial Precedent and Arbitration, an interesting area of law, directly relevant of course to many of us. It's got a subtitle, Are Arbitrators Bound by Judicial Precedent, as a question, and then it's a comparative study of the United Kingdom, United States of America and Brazilian law and practice, and it's been written by Guilherme Rizzo Amaral, and as I said before, I do apologise if I've not pronounced the name correctly, so apologies in advance. Now, Elizabeth and I talked about the book, and we've given the title of our review the following: A Fascinating Comparative Study of Modern Precedent in Three Exciting Jurisdictions: Brazil, the US and UK. And as I said, Elizabeth and I discussed the book in some detail. Let's have a look at it first of all. It's a small book, bluish cover, it's a hardback. There's the front, spine, and there's a picture of the author on the back. I'm just up close for you there. And you can see there's some blurb about the book and about the author. It runs to under 200 pages and it's got a slightly different structure. At the back is the bibliography. There isn't actually an index as such, but the bibliography is quite substantial. And it starts there on page 164, and then before that you get the actual body copy of the text and footnotes at the bottom. Quite a lot of footnotes. As I say, the index isn't there. It's always useful to have indexes, I have to say, but there isn't one on this occasion. That's the front page, the main front page there. And then there's some detail, a blurb about the book, and then some acknowledgements there. It's a detailed work and of a very high quality. The work first appeared last year, and I wrote the review earlier this year, and I'm recording it in the summer. There's the contents, the summer of 2018, the contents section there. There are two parts to the book, and it's actually split into looking specifically at, first of all, the precedents and arbitration itself, and then looking at vacating arbitral awards based on the disregard of precedents, in other words, the appeal mechanism, saying when you will not follow a particular precedent. You've got conclusions at the back and then a bibliography. Some abbreviations, very few, but useful. Tables of cases, obviously from the different jurisdictions, starting with Brazil, then coming up to a variety of different jurisdictions there, and ending up with the UK and the US there. And then we get to the introduction, and then some quotes. It's a high level publication. It's not one that is the easiest book in the world to read, and I'm not being rude to the author about that in any way whatsoever, because it presupposes that you have a reasonable amount of knowledge of the basic principles of precedent and arbitration, both certainly within the internal sphere, and therefore you've got to have some knowledge of it. But what do we say? Well, we say this. It's often said that one of the cornerstones of arbitration is the finality of arbitral awards. Basically the same with anything, really, actually, in law. You've got to end it at some stage. And an aim, of course, which most clients desire, even though it can take an age sometimes to determine a dispute, because you do have very substantial nitpicking, if I can put that word in, appeal procedures, which do sometimes drag on and on, but you do get finality eventually of awards and decisions. And so what Wildy, Simmonds and Hill have done here is, with this fascinating book, which they've called Judicial Precedent and Arbitration, is to commission Guilherme Rizzo Amaral to write it. And he poses the most specific question for all of us, and that is, are arbitrators bound by judicial precedent? A very straightforward question. And then he proceeds to answer it by way of a comparative study, which is not quite as obscure as it might at first seem. Because when I looked at this, I thought, well, I don't know much about US or Brazilian law. How relevant is it to us? And in fact, it's probably more relevant than you think. And one of the reasons I say that is because much of what I'm doing now has much more of a global content to it than it ever did in the past. Which is why when I did the bar exams 30 years ago nearly, I was really pleased to be able to look at international trade, which is my module, and get some idea of the global aspects of work rather than specifically, no disrespect to them, either the common law or chancery jurisdictions within England and Wales. Now, apart from what are considered today as rare exceptions, the arbitral awards made are not going to be subject to challenges based on the arbitrator's errors of law, because there has to be some finality, as I've indicated earlier, to any dispute as the norm for judicial policy in most decision making. And that is absolutely right. You cannot continually have some sort of appeals process, as we see in some jurisdictions, which just drag on for a very, very long time. And you get the jaundiced to jaundiced approach, where you never know when the thing is going to end. And that cannot be good for the judicial system or the legal system itself. And in addition, of course, there's no established legal hierarchy between arbitral tribunals and judicial courts, nor are arbitrators part of any judicial system, as the author points out. They are obviously seen as a different animal, if I can put it that way. Therefore, the author raises these questions, which are set out clearly in the book. Supposing there are arbitrators who are not part of any hierarchical scheme, and if there is no challenge or appeal available against their errors of law, how could one say that arbitrators have a duty to follow judicial precedents? A very interesting jurisprudential point, I suppose. The answer is it's got to come down to practice and practicality, I would suggest. Another issue, of course, which arises can be when parties might agree to solve their disputes outside the judicial arena by any of the ADR systems we currently have in place. Now, alternative dispute resolution, or as I prefer to call it, dispute resolution. The alternate, obviously, is that the main system is court and a trial, either accusatorial or inquisitorial, but you've then got the other means of trying to resolve a dispute. And obviously we have a whole series of different ways of dealing with this to try to avoid the final biggest arena, which is the court itself. And if they do then, of course, go in this direction, should the people expect a private arbitrator to abide by the same standards of a system they have just avoided? And as the author suggests, there's a quote here which I think is very useful: is the choice for arbitration not a choice for an entirely different legal system, unbound by the so-called judge-made law? And being biased, of course, as I am in favour of the common law concept of judge-made law, I would say that is the best, because, again, we do deal with practicalities, and at the end of the day, that is really what, although the law is a set of rules, it should look at the practicalities in my submission. Anyway, it's clear that this title succeeds admirably when answering those questions by presenting a comprehensive legal guide on the relationship between judicial precedents and arbitration in the three jurisdictions, the US, UK and Brazil, as well as in international arbitration generally, thus giving the reader, I think, a very wide picture to consider. And I do think, as I've indicated in many of the other reviews I've done, these comparative studies are often considered to be tedious academic theses, generally speaking, but they do have an important point to play as we try to identify common ground in some of the disputes. One of the reasons why, in fact, apart from a lot of other reasons, a lot of people come to London for the adjudication of disputes is because of the recognised system we have, apart from the fact that we have probably one of the few countries in the world where we do not have a corrupt judiciary or corrupt decision-making body the way the rest of the world has. They don't want to talk about it, but they are, and that's the biggest problem. So let me conclude by saying this. We feel that this book offers a valuable comparative study for any reader interested in the art of modern precedent, whether one is a professional practitioner, an academic, or a general reader reviewing different approaches over judicial policy on one of the bedrocks of the common law principles, that is to say, the old doctrine of stare decisis, the binding of decisions. Now, the book was published originally on the 25th of July 2017, and I'm recording it a year later. But as I say, I wanted to do this review because I thought the book was so important. There it is again, the spine and then the back. If we just open it in the middle, you can see the structure. There isn't any paragraph numbering. It's just basic text all the way through, and there is a little bit of footnoting. Sometimes rather more footnoting than one might want, but there we go. As you know, the technique with a lot of these books is to ignore the footnoting and to just go through the text and zip through it. And the book itself is 140 odd pages long at the very most. Anyway, a big thank you to Mr. Amaral and to everybody at Wildy, Simmonds and Hill for producing such an excellent work. Thank you. Bye-bye.